Hello? Hmm. Boleh start ke? Assalamualaikum warahmatullahi wabarakatuh, and a very good morning to all distinguished guests, lecturers, and participants. A warm welcome to everyone to the Space Law Talk with Ms. Rosanna D. Hoffman. Before we commence, please allow me to make a few housekeeping announcements for your kind attention. First, our distinguished guest of honor today is Ms. Rosanna. Yes, sorry. Ms. Rosanna Dim Hoffman, Program Officer and Project Lead of the United Nations Office of Outer Space Affairs, UNOOSA, at the Ministry of Foreign Affairs. Second, we kindly requested the cooperation of all attendees to remain seated until the end of the ceremony to ensure that the program proceeds smoothly with due decorum. Announcing the arrival of Yang Bersaha, Dr. Muhammad Fairuz Asilam, Malaysian Space Regulator, Space Regulatory Division MOSTI, and Yang Bersaha, Dr. Cik Zuhaida Sa'ari, Lecturer of Space Law and Advisor of Space Law Talk Program. Attendees, please be seated. Good afternoon and Assalamualaikum warahmatullahi wabarakatuh. A warm welcome to our guest speaker for today, Ms. Rosanna Dim Hoffman, Program Officer and Project Lead of the United Nations Office of Outer Space Affairs, UNOOSA, at the Ministry of Foreign Affairs. Yang Berusaha Dr. Muhammad Fairuz Asilam, Malaysian Space Regulator, Space Regulatory Division MOSTI. Yang Berusaha Encik Amirizal Bidin, Deputy President of the Malaysian Innovation Foundation YIM, Strategic Implementation Partner. Yang Berusaha Dr. Cik Zuhaida Sa'ari, Lecturer of Space Law and Advisor of Space Law Talk Program, lecturers, guests, and students. Ladies and gentlemen, welcome to today's insightful talk, Strengthening Global Space Governance, insight from UNOOSA and the Manfred Lachs Spacelaw Moot Corps. We are honored to have all of you here, and we extend a warm welcome to our distinguished speaker. We appreciate your time and enthusiasm in joining this session. Thank you everyone for joining us today. We are truly delighted to have your presence here. Yang Berusaha, Dr. To bless our ceremony this evening, the ceremony respectfully invite a few housekeeping announcements. Zahari, a student of the Faculty Sharia and Law, to lead the prayer.
Al-Fatiha. Bismillahirrahmanirrahim. Alhamdulillahi Rabbil Alamin. Wassalatu wassalamu ala Sayyidina Muhammadin wa ala alihi wa ashabihi ajma'in. Allahumma ja'al jam'ana hadha jam'an marhuma wa tafarruqana min ba'dihi tafarruqan ma'suma wa la taj'alillahumma fina wa la ma'na wa la. Man yataba'na syaqiyan wa la matrudan wa la marhuman. Allahumma ja'al khayra a'marina akhiruhu wa khayra a'malina hawatimuhu wa khayra ayyamina yawma alqaka fihi. Allahumma ghafir lana zunubana wa li ikhwanina alladhina sabakuna bil iman wa la taj'al fi qulubina alla lilladhina amanu Rabbina innaka ra'ufur rahim. We gather today to express gratitude upon your greatest gift toward us. In conjunction with this assembly, we ask for your help and guidance. Ya Allah, kindly give us strength and courage to face all the struggle and gain a wide range of knowledge. Kindly bestow blessings, physical and spiritual health, fitness of mind, peace of mind, and strength of spirit. Allahumma ya Azizu ya Qahhar. Ya Allah, give strength to our teachers and our leaders to continue to serve for people, society, nation, and religion. Ya Allah, make our country a country that got blessing, everlasting peace and prosperity of all time. ربنا آتنا في الدنيا حسنة وفي الآخرة حسنة وقنا عذاب النار. وصلى الله على محمد وعلى آله وصحبه وسلم والحمد لله رب العالمين.
Amin Amin Ya Rabbal Alameen. The ceremony would like to express its gratitude to Wan Naufal bin Wanzari for leading the prayer reading just now. To officially commence our program, it gives me great honor to Yang Professor Dr. Cik Zuhaida Saari, Lecturer of Space Law and Advisor of Space Law Talk Program, to deliver the opening speech and to officially inaugurate the Space Law Talk with Ms. Rozana Dim Hoffman. Bismillahirrahmanirrahim. Alhamdulillah Rabbil Alamin wassalatu wassalamu ala asyrafil anbiya wal mursalin wa ala alihi wa sahbihi ajma'in. Rabbi shrah li sadri wa yassir li amri wa hlul 'uqdatam min lisani yafqahu qawli. Assalamualaikum warahmatullahi taala wabarakatuh. A very good afternoon, Malaysia Times. Our respected speakers, Miss Rozana Dim Hoffman. Hi, Rozana.
Hi,
Hi.
good afternoon.
Good afternoon. Okay, Dr. Fairuz, Malaysian Space Regulator, lecturers, students, ladies and gentlemen. On behalf of University Science Islam Malaysia, USIM, and the organizing teams of the Space Law Talk series, it is my great pleasure to welcome all of you to this special Space Law Talk entitled Strengthening Global Space Governance Insight from UNOOSA and the Manfred Lachs Spacelaw Moot. Today, we are deeply honored to host Ms. Rozana Dim Hoffman, a distinguished expert from the United Nations Office for Outer Space Affairs, UNOOSA. Her extensive work in global space law, particularly in areas such as space resource governance and space situational awareness, places her at the forefront of the international efforts to strengthen the legal and institutional framework governing outer space. This session comes at a significant moment for Malaysia. With the introduction of the Malaysian Spaceport Act 2022 at 834 and the growing momentum of our national space sector, there is a clear need to build a generation of professionals who understand the legal, regulatory, and policy dimension of space activities. For that reason, University Science Islam Malaysia, USIM, has pioneered the Outer Space Law course LAC 5493, and today's talk forms an essential part of our academic exposure and capacity building efforts. At the same time, this program directly supports our preparation for the Malaysian Spacelaw Moot competition, PMPA 2025. Ms. Rozana's insight, particularly her experience with the Manfred Large Spacelaw Moot, will be invaluable for our students as they develop advocacy skill, deepen their understanding of international space law, and engage with real-world legal issues such as space debris, space traffic management, sustainability, and the peaceful use of outer space. We hope today's session will not only broaden our intellectual horizon, but also inspire our students to see themselves as future contributors to the space governance, whether as lawyers, policymakers, researchers, or international mediators. To Ms. Rozana, thank you for joining us and for supporting our efforts to advance space law education in Malaysia. And to everyone present today, physically on campus and joining us online, thank you for being part of this important initiative. I wish you all an enlightening and engaging session ahead. Thank you so much. Thank you to Yang Bersama Dr. Cik Zuhaya Sa'ari for your inspiring and insightful opening address. Your words have truly set a meaningful tone for today's event and will undoubtedly motivate all participants throughout the program. Next, we will have a talk entitled Strengthening Global Space Governance, Insight from UNOOSA and the Manfred Lachs Spacelaw Moot, which will be delivered by Ms. Rosanna Hoffman. Before that, let me introduce a little bit about the background of our speaker today. Rosanna Hoffman is the lead of our space law at the United Nations Office for Outer Space, UNOOSA, where she heads the Global Space Law Project and served as Secretary of the Working Group on Legal Aspect of Space Resource Activities and Secretary of the Expert Group on Space Situational Awareness. Her work focused on assisting countries in developing national space legislation and strengthening the global governance framework for outer space. She regularly lectures at universities worldwide and contributes to capacity building, legal research, and policy discussion on the peaceful and sustainable use of outer space. Previously, she served as executive officer at the European Centre for Space Law ECSL and junior legal officer at the European Space Agency ESA, working on the international agreement and national space law matters. With great honor, it is my pleasure to hand over the session to Ms. Rosanna Hoffman.
Thank you so much. Can you hear me?
Yes.
Excellent. Please allow me, before I do a round of thanks, please allow me to first share my screen. Oh, I see that I need to request sharing my slides. If you could briefly. Okay, perfect. I see that it works now. Let's see. All right, it should work now. 1 second. I just need to quickly approve that this works. Okay, I think it works now. Do you see my screen?
Yes, we can see your screen.
Perfect. Okay. So first of all, thank you so much for having me. Of course, a huge thanks to the university for this initiative, and of course to your space regulator for reaching out and inviting us. Firas, it's lovely to see you even from afar. It is a shame that I can't be with you in person, because I don't know if you see behind me. The snow is melting, but it's freezing cold here in Vienna, where I'm based. But it's lovely to see at least everyone virtually. So thank you so much for the kind invitation, and what a fantastic initiative indeed. I will be covering a few topics as you kindly also introduced. First, the work of UNOOSA, the United Nations Office for Outer Space Affairs. As you see on the screen, the picture is our office. It's the UN headquarters based here in Vienna. I am working from home today, but normally I'm sitting in one of these offices, and I will also be introducing the work of the Committee on the Peaceful Uses of Outer Space. Why? Because it is important to understand where the legal frameworks originated from that you will be basing your lovely arguments and discussions and academic analyses on for the moot court. And then I'm happy also to delve into the moot court competition. Why? Because it shaped my career fundamentally. I would not be where I am today if I had not participated in the moot court several years ago. So first, just a brief introduction to UNOOSA. In fact, I often get asked, what is the difference between UNOOSA and COPUS? Sometimes when we get interview questions from newspapers, we get asked, yeah, the UN Space Agency. No, we're not a space agency. We're a UN office. And you know, what is the office? What is UNOOSA? And what is COPUS compared to that? So what you see here is really the team. This is the team at UNOOSA, and I have the honor of leading our space law and policy initiatives of the office. UNOOSA is the sole UN agency that is entirely dedicated to space. You might have heard, or at some point, I hope you will hear about other UN offices that also deal with space. I'm sure at this point you must have heard about the ITU, for example, the International Telecommunication Union, dealing with spectrum allocation and management and allocation of orbital slots, or maybe ICAO, the International Civil Aviation Authority, dealing with air flight, so aircraft flying and regulating that area of the skies, or maybe UNEP, it's the environmental program of the UN. But the core difference here is that all of these entities deal with space in some way or form, but not solely. Whilst UNOOSA has only space as its mandate, it's about being the convener of global cooperation, because UNOOSA is the secretariat to COPUS, to the Committee on the Peaceful Uses of Outer Space, but it is also a capacity builder, and it provides access to space data, to information, and provides national capacity around disaster management, around space law and policy, and other areas. So UNOOSA was established in 1957, and if I were with you in person, I would ask to the students in the room, you know, what was so special in 1957? What happened in 1957? Well, by now I hope you know that this is a very special year for space, not only for the office that I get to work for, but for space in general, as it's the year that the first satellite was launched with Sputnik 1. And in the same year, states realized that space is becoming a reality. Space activities are becoming something that is actually doable. So they realized they need to urgently create an office and then subsequently a committee so that they can discuss the peaceful use of outer space, so that they can make sure that the peaceful use of outer space is secured, and that whatever conflicts are happening on Earth, whatever geopolitical tensions are at play, especially think back to the 50s and 60s, potentially similar to where we are today, but nevertheless, to have a forum where they can discuss and cooperatively discuss the peaceful use of outer space. So I hope you know what UNOOSA is. But what is COPUS? So UNOOSA acts as secretariat to COPUS. And in the kind introduction, it was already mentioned that, for example, I am secretary to the working group on space resource activities and the expert group on space situational awareness. But the committee is a lot more than that. And this is a room where your space regulator has sat, and hopefully you will sit in the future representing Malaysia, and this is really the birthplace also of the 5 United Nations treaties, and we'll see how that came along. So COPUS was established just a year after UNOOSA, the office was established, first as an ad hoc committee and then as a permanent committee already in 1959. And again, it's so important to think about the historical context, because it's amazing how quick these things happened. You know, from the first launch of the satellite to the establishment of an office, then already to the establishment of a committee, all within the span of 2 years with the permanent committee. It is truly quite impressive, I have to say. Also, again, looking back to the geopolitics that took place at that time. And why was it established? Well, it was established to review international cooperation in the peaceful uses of outer space. It is established to organize mutual exchange and dissemination of information, and this is now to the core of the work that you'll be doing, study legal problems arising from the exploration of outer space. It started with around 18 member states when it was a permanent committee. And today we already get to talk of 110 member states. Why? Because just 2 weeks ago at the General Assembly, it was agreed to admit another 6 member states to the committee. Those are Côte d'Ivoire, Gambia, Honduras, Maldives, Malta, and Zimbabwe. So that means as of end of this year, beginning of next year, we really have 110 member states. And that is really quite exciting, I have to say. COPOS is the main committee, and it has 2 subcommittees. One legal subcommittee, which meets around April every year. It's my favorite, as you can imagine. And one scientific and technical subcommittee, which meets around February each year. Very interestingly, COPOS bases all of its decisions on consensus. Now, I take that most of you, if not all of you, are studying law in some way or form. And by now you should be able to define what consensus means. But if you're unsure, let me briefly explain. Consensus means that decisions are not taken by vote. So there's no voting taking place. Consensus means that everyone in the room, Malaysia, the Russian Federation, Gambia now, smaller states, everyone at the end of the day needs to agree with the decision that's being taken. And not only the decision, but it needs to agree. So everyone in the room needs to agree with the content of a proposed text. And now, when I mean proposed text, I mean the treaties that you know, or resolutions that you might have looked at, or non-legally binding instruments such as the Space Debris Mitigation Guidelines or long-term sustainability guidelines. So consensus has a very strong legal effect. And what is, again, impressive is that no matter the geopolitical landscape, and, knock on wood that it will continue like this, but no matter the geopolitical landscape and the difficulties around the world, within this committee, states have continued to be able to agree on specific reports, texts, non-legally binding instruments, etc. So this is really fantastic. The committee reports. So you might have heard of the General Assembly, right? The General Assembly of the UN that meets in New York. The General Assembly has different committees, and COPOS belongs to the 4th committee, and it reports to that committee. And a yearly resolution is adopted at the 4th committee based on the outcomes of COPOS. Now, COPOS has, as I mentioned, these 2 subcommittees, right? I mentioned the scientific and technical and the legal subcommittee. And within those subcommittees, and this is as technical as it gets, then we'll talk law. But it's important to know this because this is where law is being developed. This is where non-legally binding instruments, principles are being developed. So you should know them because you will probably be referring to the text that these working groups are working on in future space law competitions as well. So within the scientific and technical subcommittee, we have several working groups. A very important one for the work that you will be doing is the working group on the long-term sustainability of outer space activities, as this working group developed the LTS guidelines, the long-term sustainability guidelines. And seldomly in the last few years have I seen a moot court case where you would not in some way or form need to see how the long-term sustainability guidelines could apply in the case. Yes, they're non-legally binding, but could you argue that the LTS guidelines can be used as interpreting other obligations within the treaty, for example, obligations within Article 9 of the Outer Space Treaty? Could you use the long-term sustainability guidelines as a form of subsequent interpretation methods? The ICJ has often said not often, but has stated in previous cases that also non-legally binding instruments, when adopted in the same treaty-making body as the core treaties, can be used to interpret obligations. So interesting to note, and please consider looking into these types of legal analyses. Recently established in June is the expert group on space situational awareness. And within the legal subcommittee, there are 3 working groups. And I know that the chair of one of the working groups recently had the pleasure of being with you in person, Professor Stephen Freeland. He's the chair of the working group on legal aspects of space resource activities. And I have the honor of being the secretariat to that working group. So we will look at that in a little bit more detail, because that will also be really relevant to the work that you will do. But there are other working groups too, for example, on definition and delimitation. What does this mean? Where does outer space begin? This working group has existed since more than 30 years and has not reached consensus. So there is no agreement to be found on an internationally recognized definition of where outer space begins. That doesn't mean that some national laws haven't identified this for themselves. Australia clearly identifies 100 kilometers as the delimitation of where outer space begins, the definition of where outer space begins. The US has more of a functional definition, so where airspace ends, outer space begins. The question is, do you need this in a national law? That's a discussion for another day. But just to also showcase that there are some working groups where no consensus can be found, but the discussions are important to be had anyhow. I just wanted to share with you a broad overview of the topics that are being discussed. Topics meaning, what are the different agenda items that are discussed within COPUS? And I'd like to give you one example. Why? Because it was also a moot court case 2 years ago. In fact, the case that I got to draft, the topic of dark and quiet skies and large constellations. This is an agenda item that was very hard fought. Last year at STSC, member states, after, as I said, a lot of initial disagreement, were able to agree that there is an inherently important need to address the concerns that astronomers have in regards to light pollution and other type of pollution that might affect might affect both ground-based and space-based telescopes. So the issue of dark and quiet skies was agreed, but there needed to be a compromise. The compromise was, well, if we discuss dark and quiet skies, then only in connection with the issue of large constellations, because some member states said, well, yes, we agree that dark and quiet skies needs to be discussed. We agree that this is an issue, but we are of the opinion that it's large constellations that are so detrimental to astronomy. And if we discuss dark and quiet skies, then only in connection with large constellations. So this is how diplomacy works. I'm sure that you've already had an overview of what the Working Group on Space Resource Activities is doing, as you had the chair with you just recently. But I want to point out one thing, because also here, I think it will be really interesting if you do venture into solving a moot court case in the near future. You should know that this working group has already developed a set of draft principles. Yes, they are drafts at this point, but they are openly accessible on the working group's webpage. And of course, looking into the drafts and using the draft can also help you. It is not a binding treaty. However, does it showcase some type of general understanding of the interpretation of Article 2 of the Outer Space Treaty, Article 2 dealing with non-appropriation? Potentially. That is an argument that you as students would have to or not have to counter argument or make the argument. So consider also, again, these draft principles. They are already available for you to use. They are drafts, yes, but do they already potentially showcase a general understanding over some of the issues? Maybe. It is an argument for you to make or not make. Okay, I don't want to focus too much on this, but just so you know that in parallel to the work that's going on in the Space Resources Working Group, it was established. So the work plan was established this year, but the proposals were made last year. There is an action team on lunar activities consultations at Lachs that was established, and whilst the working group on space resources is working on principles that would be applicable to space resource activities, right? The exploration, exploitation, and utilization of space resources, Lachs will deal more with coordination. So now imagine you have the moon, and you might know everyone wants to go to the South Pole of the moon. There is potential ice to be found there. Ice could potentially mean water. Water could potentially mean CO2 and other type of materials needed to create a permanent human presence on the moon. And now you can imagine that those countries that are wanting to go to the moon might all want to go to a similar area of the moon. And it's important that the moon does not become an area of conflict or disagreement. So Lachs is really there to create mechanisms around coordinating these types of activities, making sure that member states inform each other of the activities that they are planning to do and thereby not step on each other's toes. This is the newest type of forum created under COPUS. It's the Expert Group on Space Situational Awareness. It was established just this June under COPUS, and it's really all about space traffic coordination. Right? You all know that space activities are growing. You know that there are more and more satellites that are being launched into outer space. You know that there are some orbits that are more congested than others. And you might know that there are situations where near misses are happening more frequently. And STC is becoming a real need. But the issue is that we need global space traffic coordination. There's no point in having it done regionally. There's no point in not involving everyone, because that is really completely takes away the effect that STC can have. The reality is that this has to be done globally, and member states saw this need and have established this expert group. The work is just starting, so hopefully in the future I'll be able to update you a bit more on the work of this expert group. So now to space law, but it was important that you understand this background of COPUS and how UNOOSA supports COPUS, because when we talk about the existing international framework, we talk about frameworks that were all developed here at COPUS, maybe except for the ISS-IGA, which is also an international agreement treaty. And in fact, when I was doing the moot court competition, I had to also look at that specific agreement together with the outer space treaties. But beyond that, all of the existing international frameworks were developed at COPUS and adopted by consensus. So there is a very nice timeline in regards to when things were developed and adopted, in the 50s and 60s, discussion started, right? So it started with the adoption of a resolution in 1961 that is the foundational basis for the Outer Space Treaty. The Outer Space Treaty, which then entered into force in 1967 with 4 subsequent treaties after it. Then we say it's the end of the treaty-making era, around 1980. And then from the 2000s onwards, we really talk about the development of soft law. Some people don't like the term soft law. Maybe you prefer non-legally binding instruments. But the point is that it's not binding treaties. It's non-legally binding, but it's more technical in nature. And it makes sense that it's not legally binding, because meaning more technical in nature means that you need to have the flexibility that you can change these non-legally binding instruments. When we talk about specific requirements for the long-term sustainability of outer space, I am beyond certain that there will be other additional requirements 5 years in the future. Treaties give us high-level principles on which non-legally binding instruments can build upon. So here, oh, apologies, there was some movement on the slides, but here you have all of the treaties and principles that were adopted. R stands for ratified, S stands for signed. And as you can see, for the Outer Space Treaty, for example, we have 117 states that have ratified the treaty. That is really good. 23 that have signed. And for the other treaties as well, the Rescue and Return Agreement, the Liability Convention, the Registration Convention. And just last week, let me briefly make this brief divergence to one of the treaties, the Rescue and Return Agreement. Just last week, we had a space law conference taking place here in Vienna, and one of the panels delved into the Rescue and Return Agreement. And I invited the experts on the panel, and I had assumed, well, everyone will talk about the Rescue and Return Agreement from an academic perspective. I want them to talk about it from an operational perspective, but let's see what they have to say at the end of the day. What was mind-blowing was that every single expert on that panel had an actual national example of a piece of space object landing in their territory and how the Rescue and Return Agreement is being operationalized. Now, if you haven't read the Rescue and Return Agreement, I recommend you do. I believe a lot of future moot court cases will delve around that issue more and more. Why? Because when we talk about the astronaut rescue and return agreement, we always think it's about astronauts. And yes, the first 4 articles of the treaty are about astronauts, but from Article 5 onwards, it's about space objects. And it's about space objects landing in foreign territory, so potentially your territory or your neighbor's territory. And it's about understanding what are your rights and what are your obligations if this happens, and how can the UN support in these situations. And just this year, approximately on a monthly basis, we're receiving formal and informal notifications by member states of space objects found in their territory. So I would say it's a treaty of our time. It is definitely not outdated, as some might say the treaties are. Quite to the contrary, I believe that all of these treaties are actually coming to life. And that is also where the moot court competition is so important, because you are then the ones to delve into the treaties with cases that are real life, that could be very real in the very near future, if not already today. There are some other United Nations instruments, and please don't forget what I said before. Use these non-legally binding instruments to interpret obligations found within the treaties. Don't only base your arguments on the treaties. Use every single resolution that was adopted by the General Assembly. All of these have been, and use these really to strengthen your arguments. Again, don't forget, these were adopted all by consensus. So important, and will really strengthen any arguments you're making. Now, I don't want to spend too much time on UNOOSA's other mandates, but just very briefly, as this might be interesting also to to the work that you're doing, the analysis, the research. As you might know, states have an obligation if they're considered a launching state. And now, what does it mean to be a launching state? By now, I hope you know, but if you don't know, there's 4 ways of being a launching state. And even if Malaysia has not yet built its spaceport, it can still be considered a launching state, because procuring a launch is also considered as one of the ways of being defined as a launching state. And once you request, pay for, or in any way are involved with a satellite being launched from elsewhere, you are considered as procuring a launch, so you're considered a launching state. Now, long story short, what does it mean as a launching state? You have several obligations. One of them, but you also have rights, by the way, very important. Under the rescue and return agreements, you have many rights. But under the Registration Convention, you have an obligation, and also under the Outer Space Treaty, to register your satellite. Register your satellite nationally. That gives you jurisdiction and control over your satellite. And register your satellite with the UN. Now, if you will delve into moot court cases, etc., you might want to look at that register. You might want to look at what are the different registration practices that are ongoing. Maybe you can, through that analysis, again, find some type of emergence of customary international law. Maybe you can find some type of general understanding of how and who should register. And I just want to go back here. There's even a recommendation on registration of space objects resolution that you can look at. So again, use all of these different tools that are out there to strengthen your argument and your case. This is just to showcase the growing number of registrations received at the UN. Yes, so now to move on to, very briefly, the work that I have the honor of doing at the UN beyond my secretariat functions is heading our Global Spacelaw project. And thanks to that project, we have had the pleasure and honor of being in Malaysia a few times, and we hope to be back again. But what is it we do? So UNOOSA has several mandates that it has received by COPUS, and one of these mandates is to specifically, it requests UNOOSA to provide space law technical advisory missions. And in fact, this is a lovely image, and this is fully random, by the way, Firos, but it's nice to see that the image is of a technical advisory mission that we did to Malaysia not so long ago. And what is it we do? We do these technical advisory missions to advise on the drafting of national law, national policy, looking at legal aspects of establishing a spaceport or launch facility, looking at the legal aspects of establishing a space agency, drafting national regulation, helping identify who the potential regulator should be, etc., etc. And why is this important? And we're going back to one of the first slides I had. Remember the year 1957, the launch of the first satellite. Well, where are we today? By 1957, 1958, we had around 2 states that had a satellite launched, or that launched a satellite. Now, in 2025, we talk of 105 states with at least 1 satellite in outer space. What does it mean? It doesn't mean that 105 states have a launch facility and actively launched a satellite. No, it means that 105 states have in some way or form procured the launch of a satellite. So they have a satellite in outer space. And I created this slide in October. End of September, the latest satellite that was launched, so that was when we found the number 105, was Botsat-1, a satellite, the first satellite of Botswana. But probably I should now look at this again, and we are probably at 106 states by now or more. So this slide is really difficult because I need to update it all the time. So let's briefly recap space law before we jump into the moot court. Why space law? What is the raison d'être of the early space law era? Well, it was to prevent outer space from becoming an area of conflict. It's about strengthening international cooperation. If you look at the Outer Space Treaty, and where do I have it? I have it in here. I always have it in my desk. The treaty booklet. If you look at the Outer Space Treaty and all of the other treaties, you will see that there is a foundational component to it, and it's throughout all of the treaties. It's about international cooperation. It's about peaceful uses of outer space. It's at the basis, and that's a right and an obligation. So when you make your arguments in the moot court, always consider, what is the purpose of the treaty? What did member states try to achieve when they adopted this treaty? What are they prescribing to when they ratified the treaty and the subsequent treaties? And a very important point is also distributing space benefits between all states. This is, by the way, one of the really important aspects that the Space Resources Working Group is working on, topics around benefit sharing on space resource activities. But if you look at the treaty, these notions existed already in the 60s. So again, something to consider when making some arguments. A really important core obligation of the Outer Space Treaty is the need to authorize and continuously supervise activities by non-governmental entities. Now, that is again something to consider for your moot court, but also to understand why it is so important to have a national space law in place. And why are we talking about space law more today than we've ever done before? I showed you the slide before with 105 states having launched a satellite. What does this mean? This means 104 states are legally responsible in some way or form for the satellite. According to Article 6 of the Outer Space Treaty, they are responsible for national activities, whether these are governmental, non-governmental, academic, whatever. If you're planning to launch a CubeSat, Malaysia will be responsible for that activity. So imagine 105 states legally responsible for something happening up there. And potentially, if it's a non-governmental entity that is doing this activity, they also have an obligation to authorize and supervise. And if something goes wrong, if Malaysian territory gets damaged, if a piece of debris lands on Malaysian territory, you have rights. You have right to compensation. You have right to initiate diplomatic channels and also receive compensation for any financials incurred by removing an object, right? Or any damage that was occurred. So all of these issues, we often talk about obligations, but it gives you so many rights as well. So with the growing number of the privatization and commercialization of outer space comes the inherent need to look at space law also from a national and regulatory perspective. And it's important to note that space law and law in general needs to be seen as an enabler, because wherever humans went, law followed, and it provides secure framework conditions. It provides a predictable investment environment. It gives your industry and universities and investors clarity. So all of this is truly beneficial for a country. So I really want to go ahead to the moot court section. So just a brief summary: why national space law? The treaties have these high-level principles that need to be implemented nationally, and they can really reflect all of the national realities and expectations that a country might have. There are 7 key elements, and again, a picture from Malaysia. I think this is fantastic. I have to say my intern created these slides, and I have to give him thumbs up because this is great. So we have 7 key elements of a national space law, and also here, consider this resolution. It was adopted as a resolution by consensus in 2013. Build your arguments around this. when dealing with the moot court case. Two tools, and I swear, look, this is my moot court slide, but two tools that might be interesting for you when delving into the moot court preparation, whatever. On the one hand, we have the ASTRO database. It's a collection of all national space laws and policies. It's also, by the way, includes all of these treaties and principles and additional resolutions. Everything I mentioned is on this database. So very easy for you to use, to reference. And then we have 4 e-learning modules. So if you still feel, after hearing amazing lectures by your own professors on space law and by your invited experts such as Professor Freeland or whomever, if you still feel you want to learn more about space law, we have 4 space law e-learning modules. They're openly accessible, free for all. Just do it in your spare time. And we also have 2 additional modules that have been developed since the space law modules, one on space economy and one on the LTS guidelines. So this might be interesting to you. Now on the moot court. I'll tell you why the moot court was so important to me, but maybe first why it is important for you and how this might help build national capacity, but really also help you, and I'm talking to you as you, meaning the students in the room, why this is so beneficial. So first of all, I believe there's no other type of format that allows you or makes you delve into a specific legal area as deeply and as precisely as working and preparing for a moot court competition. When I had to do the moot court and prepared for my participation in the moot court competition many years ago, we had to work on the case for nearly a whole year. Can you imagine delving into purely space law? Of course, there were other exams that I had to do in law school in parallel, but the main focus was the moot court competition every evening, every weekend. And never have I delved into a specific area of law in so much detail, but it was because of the moot court competition. And you'll have cutting edge issues, state responsibility, liability, registration, but also when we talk about moot court cases, they're forward thinking, right? They're going to deal with space resources. They're going to deal with security related issues. I added the ISS IGA because seldomly, maybe you do it in Malaysia, but when I studied law, we did not look at the IGA in detail, but it is also a treaty. And it actually is quite interesting to see and delve into the IGA because it deals with criminal law in outer space. Can you imagine? And IP law, etc. So again, it really makes you delve into some issues in a lot of detail. And it helps you develop advocacy skills. So it helps you develop written and oral advocacy skills around complex treaty interpretation. To this day, I'm not saying I'm a good public speaker, but if I learned anything from the moot court beyond, of course, the knowledge it gave me around space law and policy, it is about being able to answer questions in very difficult situations because you'll have to practice for that. Judges will ask you difficult questions and you need to lean into the questions. You need to accept them with open arms, and it doesn't matter if you know the answer or not, but you make them think you know the answer. And this is really a skill that in my law school, I did not learn by going to lectures. I learned this by preparing for the moot court and taking part in the moot court competition. And of course, it really allows you to get access to a global professional network. Why? Well, you connect with other students, you connect with academics, practitioners, judges. Why? Because no matter what type of moot court competition you will participate in, but whether it's a national, regional, global, your judges will be practitioners, your judges will be experts. They will be, institutional experts from around the world, and you will be able to have the chance to really network with them. And from my experience, and I'll tell you why my experience is so across the board with the moot court, it really gives you career visibility. Many alumni from moot court competitions go on to careers in multilateral diplomacy, so either as part of their government delegation to the UN, or even working for the Ministry of Foreign Affairs and based with the permanent missions, to working for international organizations, national space agencies, academia, specialized law firms. Having this in your CV, and together with the network that you were able to create, it's really helpful. Now, just really briefly, my case. I don't want to in any way focus on me too much, but just to give you an example, I started with the moot court competition as a participant. I was a mootie. We made it to the world finals of the IISL moot court competition. So what does this mean, to make it to the world finals? The world finals means that you won your national rounds, you won your regional rounds. So we had to beat all of the 25 whatever law schools in Europe, and then you make it to the world rounds, meaning from each region there's a team competing, and then in the world finals. But this is for the IISL moot court. It will depend how you will want to participate. You actually have 3 sitting ICJ judges judge. Can you imagine? Not only was this the most nerve-wracking experience of my career, most likely it was, but it's also probably the only time I will be sitting across, or you could potentially be sitting across, 3 living, sitting ICJ judges and pleading in front of them. So beyond exciting experience. From then, I had the honor of coaching a team at the University of Vienna. So went from a participant to a coach. Then I started working for the European Space Agency and the European Center for Space Law, which organizes the European rounds. So then I organized the moot court. I judged the moot court, both regionally and globally. Then I was asked to draft the case for 2024. It was all about dark and quiet skies. So if you look at old cases, the dark and quiet skies case is very exciting. And now I have the honor serving on the moot court committee, specifically responsible for liaising with the authors of each year's case. So you see, it's really a round circle moment. For me personally, it was the start of my space law career. And I hope that it will be for you as well, if that is what you want. And I'm happy to take any questions. Thank you so much.
Thank you to Ms. Rosanna Dim Hoffman for the enlightening and insightful presentation. Ladies and gentlemen, the floor is now open for a question and answer session with Ms. Rosanna Dim Hoffman. We encourage students to take this opportunity to ask any question they may have. Feel free to drop your question in the chat box or turn on your mic if you would like to ask directly to the speaker. Feel free to open your mic and ask direct to. Hi, hello. So I have a question. So how can developing countries ensure that they have an equal voice in shaping future space regulations? Yeah, that's my questions.
Thank you so much for that question. Well, as I said before, right, Corpus works by consensus. So that means that if you want a developing country has, wait, I think you need to switch off the sound in the room. Yes, there we go. If you want to call it a developing country or emerging spacefaring nation, has just as much a voice as a spacefaring nation. So, Zimbabwe in the room will have just as much a voice as the US. If Zimbabwe is not happy with any decision being taken, any language being added, for example, in the draft principles on space resource activities, right? They can raise their plaque and they will say this, and it will not be adopted. And that is where consensus is such an amazing tool, I would say, to give voices to emerging spacefaring nations, because at the end of the day, every voice plays an equal role in the room. It doesn't matter how large, how small, how big your population, how big your financial means are. It has no role to play whatsoever. Every country has the same voice. What is important, however, and I do make this recommendation, and Malaysia is very good at heeding this recommendation, but others may be less so, just because of their lack of human resources, I would say, is you need to participate in the meetings. We have a lot of member states, especially emerging spacefaring nations, that are COPUS member states, but they're not in the room. They're not taking part in the discussions when they have the chance to. So whenever I do my Spacelaw technical advisory missions, whenever I fly around the world, it is the one core message I try to give government officials is please send your representatives to COPUS, please have them participate, because only if they participate, only if they're in the room, they have a voice. So I hope this answered your question.
Thank you for answering my question, Mr. Zana. Any question from the floor? Okay.
Hi, my name is Ifa, and I have a question for you, which is, does country with no space law treaty is bound to comply with the regulation as stated in the treaty? And if no, how can they be legally liable? Thank you.
Thank you so much. Now you're mixing up a lot of terms, I have to say. So we have to unpack that question a little bit, right? So you mentioned the Outer Space Treaty, and then being party to the treaty, but then being liable. So let's unpack it. The Outer Space Treaty has 117 states that have ratified it. Most, if not all, so all spacefaring nations have ratified the treaty. There's no need to ratify it if you're not, there is a need to ratify it, but you won't be bound by the treaty if you don't do a space activity, but you won't benefit from the benefits either. So even if you're not a spacefaring nation, and for example, a piece of debris lands in your territory or damages a house of one of your citizens, you cannot use the liability convention, right? You haven't ratified it. What is very interesting, and oftentimes government officials aren't happy to hear this, but it is a fact. Whether or not you have ratified the Outer Space Treaty, specifically the Outer Space Treaty, doesn't really have much to say, because most of its principles, including Article 7 on liability, are considered customary international law. So the country will most likely be bound by those core obligations. I'm talking the high-level core obligations anyways. What, however, the detriment is that you will not be able to benefit. Yes, you cannot benefit from the subsequent treaties if you haven't ratified them, the Rescue and Return Agreement, the Liability Convention, and others, because they give you rights, right? They explain whom you can sue in case of damage, who you can, what you can request for compensation in case of removal of a space object, these types of things. So I don't really see this to be a big issue right now when it comes to ratifying the Outer Space Treaty. Again, that has 117 ratifications, and as I said, most principles considered customary international law. But when it comes to the other treaties, it's a bit different, and here I would really recommend that ratification take place.
Thank you. Any more questions? No? No? Okay, and with that, thank you to Ms. Rozana Dim Hoffman and all participants for this engaging and relevant session. To officially mark the end of our program, it gives me great pleasure to invite Yang Berusaha Dr. Muhammad Fairuz Asilam, Malaysian Space Regulator, Space Regulatory Division MOSTI, to deliver the appreciation and closing speech.
Thank you. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh, and very good afternoon. Thank you, Roshana, for giving your precious time to share your experience to the students. I would like to express my heartfelt appreciation to University Science Islam Malaysia for graciously hosting this special talk session held in conjunction with Malaysian Spacelaw Moot Court Competition 2025. This collaboration reflects USIM's continued commitment to promoting academic excellence and advancing the national discourse of space law and governance. My deepest gratitude also goes to Madam Rozana Dim Hoffman, head of the Global Space Law Project and the Secretary of the Expert Group on Space Situational Awareness, United Nations Office for Outer Space Affairs, UNOOSA, for her unwavering support and friendship toward Malaysia space law development since the UNOOSA Technical Advisory Mission 2024 and before that. Her contribution have been instrumental in enhancing Malaysia's understanding of the importance of the UN space treaties, which ultimately guided Malaysia's accession and ratification on the Convention on Registration of Object Launch into Outer Space Registration and the Outer Space Treaty OST 1967. Malaysia is now actively preparing for the ratification of the agreement on the rescue of astronauts, ARA 1968, and the Liability Convention by 2026, inshallah, a milestone we look forward to achieving with enthusiasm and pride. Rozana's also continuous engagement and knowledge sharing have greatly inspired us to align Malaysian national framework with international best practice and ensure that our space activities are conducted responsibly, safely, sustainably, especially as a global space environment become increasingly congested. I would also like to extend my sincere appreciation to all of you, USIM students, and organizing committee member who work hard to make this event possible. And special thank you to Dr. Cik Zuraida for make this event happen successfully. Your efforts are highly meaningful and commendable. This experience is not only valuable, but also serve as a foundation for your future contribution. May all of you continue to succeed and one day give back in whatever capacity you can, particularly in the field of space law, inshallah. The nation needs the voice of young lawyers, the voice of you all, to safeguard Malaysian interests both on Earth and in outer space, while also supporting the UN cause or the international agenda to make space more peaceful, safe, and sustainable. Once again, my sincere thanks to USIM, the Malaysia Innovation Foundation, YIM, and all partners who make this session success. Thank you very much. Terima kasih.
Thank you, Yang Bersaher, Dr. Muhammad Faris Asilam, for your meaningful appreciation and motivating closing remarks. Your presence has truly added significance to our event. We would now like to invite all guests, lecturers, and students to join us for a group photography session with Miss Rosanna Dimhoffman. Kindly turn on your cameras for a moment and we will take the photo shortly. For all attendees, we kindly request everyone to move forward. Aku duduk sini juga. Aku duduk sini juga. Oh, snap from here. Kita mau Okay, everyone ready? So 1, 2, 3. 1, 2, 3. 1, 2, 3.
Wait. Okay, okay, one more freestyle.
Freestyle.
One,
1, 2,
2,
3.
Okay, one more time. Okay, wait. Okay.
Okay, everyone ready? So 1.
Yeah. Pin.
Guys.
Okay.
Kalau princess